It was 16th April 2024 in a courtroom in Accra, Ghana. A judge handed down a 10-year prison sentence, but the woman being sentenced was not there. She was thousands of miles away in the United States. This was Sadinam Tamaklo. She had already spent 4 years as CEO of Maslock, the microfinance and small loan center, Ghana's agency for providing accessible financing to businesses. Then in 2017, Yoko opened an investigation that put her tenure in question. That investigation grew rapidly. It began with a company called Obatampa. Maslock had loaned the company 500,000 Ghana cedis at 24% interest. Obatampa considered the interest too high and tried to return the money by check. Sadinam allegedly insisted that the money be paid back in cash instead, so the board chairman personally delivered the 500,000 Ghana cedis to her at a filling station in Bachuna, Accra. A letter later surfaced, supposedly signed by Sadinam, acknowledging receipt of the money. A few years later, a new Maslock CEO checked the books and there was no record of the 500,000 Ghana cedis in their books, and the conclusion was irresistible that Sadinam had stolen it. And that was only the beginning. The Maslock board had approved 1.7 million Ghana cedis for sensitization programs, including a 20 Ghana cedi per beneficiary transportation amount. Yoko alleged that Sadinam withdrew 1.8 million, but only 1,300 Ghana cedis was accounted for. The rest disappeared into thin air. Another 246,000 allocated for financial literacy training also disappeared. And then there was 1.4 million Ghana cedis set aside to support victims of the Kantamanto fire. Yoko alleged that Sadinam pocketed 479,000 Ghana cedis, and that money never reached the beneficiaries. That wasn't the end. Then came vehicles, 350 Chevy Avios, Sparklights, and Isuzu buses, allegedly purchased without PPA approval. Despite securing tax waivers, Maslock allegedly paid 74,000 Ghana cedis for a Chevy Avio that was selling for 47,000 at the showroom. Samsung phones were allegedly purchased for about 93,000 Ghana cedis when their market value was around 24,000 Ghana cedis. The allegations eventually produced 78 charges, which included stealing, willfully causing financial loss to the state, causing loss to public property, improper payment of public funds, money laundering, unauthorized commitment of government funds, and breaches of the Public Procurement Act. Indeed, the charge sheet was so dense that the prosecution made numbering errors. At the High Court, Sadinam participated in the proceedings until she asked for her passport to be released so she could travel to the United States for medical review. The court granted the request on the understanding that she would return by October 2021. She did not. Her bail was breached and the trial continued in her absence. The prosecution called 7 witnesses, including her driver, her successor at Maslock, Mr. Stephen Amwa, and Obatampe's board chairman. Sadinam was eventually found guilty on all 78 counts, and the state was ordered to pursue proceedings to recover her assets. But within a month, her lawyers appealed. They argued that many of the charges were legally defective and too vague to tell her precisely what she had done, and that she had denied signing the Obatampa letter, and that the prosecution had failed to prove her guilt beyond reasonable doubt. The Attorney General fought back. They argued that Sadinam, having fled the country, should not be allowed to appeal. It argued that the charges were not defective. The prosecution also maintained that the evidence was sufficient, pointing to the fact that Maslock regional directors had reportedly indicated in audit responses that the programs for sensitization had never taken place. The court found that the objection raised that Sadinam was a fugitive was not properly brought, but it addressed the issue anyway. The position it came to was that an appeal was a constitutional right and could not simply be taken away because a person had been sentenced in absentia. Sadinam had also complied with all the procedures for her appeal, and so the matter had to proceed. 34 of the 78 charges were found to be legally defective. Some of them were so vague that they failed to identify precisely what act or omission had caused the financial loss. Some even contained allegations extending into 2018 a period after which Sedinam had left office. For example, Count 54 read that Sedina Christine Tamaklo Ationu and Daniel Axim, on or about the 20th July 2016 in Accra, agreed to act together with a common purpose to willfully cause financial loss to the states. Where were the particulars that could justify and establish what exactly they did wrong? The Obatampa allegation also began to unravel. Sedinam had denied signing the letter acknowledging receipt of the 500,000 Ghana cedis. Although the signature appeared similar to hers, the prosecution had failed to prove beyond reasonable doubt that she actually signed it. The sensitization issues also suffered a blow. The prosecution had not established whether the thousands of beneficiaries had actually received the money, and instead of calling witnesses with direct knowledge of what exactly happened in their regions, the prosecution relied on an auditor who was repeating information obtained from others. The court found rightly that this was inadmissible hearsay. The charges relating to the Kantamanto fire also collapsed when Stephen Amoah testified that the audit findings had actually cleared Sedinam and that the victims had received the money. With the underlying offenses disappearing, the money laundering charges also fell with them because money laundering depends on the existence of proceeds from other offenses, and these other offenses had not been proved. The allegation that Sedinam had improperly paid herself an ex gratia amount of more than 160,000 also failed. The head of finance testified that the payment was consistent with the terms of her appointment letter. And then came the vehicle procurement allegations. The prosecution had alleged that Sedinam had entered into the transactions without the necessary authorization and had used a single source procurement without approval from the PPA board. But the prosecution failed to prove these alleged procedural breaches. And then there was another problem. The payments had subsequently been authorized by Stephen Amoah, her successor, after Sedinam had already left office. By the end of the appeal, the prosecution's case had been substantially dismantled. The Court of Appeal concluded that the evidence had fallen short of the standard required in a criminal case, proof beyond reasonable doubt. So on 30th July 2026, the Court of Appeal delivered its judgment. Sedinam Tamaklo's conviction was quashed. She was acquitted and discharged on all 78 counts. What do you think? Follow Superlaw GH Studios for more. Real stories, real cases, real people.